Okay, good morning, everybody. I just heard that the clock is a bit slow and it's already 10:05, so we should start with the second part, or the second press conference, after having the opportunity to hear about Mr. Drutza's report on the Data Protection Directive for the law enforcement sector. We now come to the General Data Protection Regulation, which has been proposed by the European Commission beginning last year, so at the 24th of January 2012. It's almost 1 year ago. And during the last year, we did a quite extended work on this proposal. Me and my colleagues, the shadow rapporteurs of the different political groups, we had an extended amount of technical meetings and meetings with us to debate the draft regulation, which is a quite comprehensive file, almost word by word, and that of course takes time. Many of those meetings with representatives of the Commission and also of the Council to get the different perspectives in the institutions, and of course myself as the then appointed rapporteur of the competent Civil Liberties, Justice and Home Affairs Committee. I did during the last year about hundreds of individual meetings with different stakeholders and 2 hearings in the European Parliament, a joint parliamentary meeting which was 2 days also on the directive with our colleagues of the national parliaments and with many stakeholders around. And of course, I also visited really many conferences, especially of different business sectors here in Brussels, but also all around in Europe. I sometimes really wonder how all that fit into a timetable of European parliamentarians, which is already quite fixed with all these meetings here in Brussels and in Strasbourg and our whole travel time. So that was a really extended work from all colleagues on this regulation, and this work with all these results and all these inputs and concerns and questions got into my work on a draft proposal for this regulation, which now is online, available on the website of the European Parliament. I very much hope that during the day there's also, or already, I don't know, the translation in all official languages available. And tomorrow, our 2 reports, the 2 proposals on both dossiers, will be presented in the Civil Liberties Committee, in the Libe Committee. And from then on, we will have a next round, a new stage of the debate in the European Parliament. We will have, in parallel, the already proposed drafts in the opinion committees voted, and then a round of amendments coming in the Civil Liberties Committee, and hopefully the possibility for many compromise amendments in March and April. The foreseen vote on our reports is end of April. We will try to manage it. We want to stand ready for negotiations with the Council of Ministers, and we hope that we can start negotiations on these files within the Irish presidency, which already have committed also in rounds with us that they want to work strongly on both dossiers, and especially on the regulation, which of course needs many time in the debates. The presidency has said that they will plan a huge amount of meetings in these 6 months, and therefore I really trust that we have the possibility to get together with the Council on common mandates in summer and start negotiations on the final legislative provisions. We are here, of course, today to take an important next step in formulating the fundamental right on data protection in Europe, at the same time strengthening trust and innovation in the European digital market. And therefore, my report proposes the following 10 clarifications to the Commission's proposal. First of all, data protection is a fundamental right, and that has to be visible in the legislative dossiers we are preparing on data protection. With the Lisbon Treaty, the Fundamental Rights Charter gets into force as a binding charter for fundamental rights of all European citizens. Everybody has the right to ask for these rights to be protected, and also that these rights are enforced in courts in Europe. And of course, also with the Lisbon Treaty, we have the Article 16, which is lining out one single legal base and one basic provision for data protection in Europe. It's lining out that data protection is a fundamental right, that it needs to be protected in all areas, where the European Union at least is competent in EU law, and that these protection should be carried out by independent data protection authorities. And I would also like to add that, of course, the citizens in Europe, which are around 500 million, they expect that if the European Union draws law on fundamental rights, is respecting and protecting their fundamental rights on the highest level possible, and that we are not undermining the fundamental rights provisions in the member states and in the Fundamental Rights Charter, as well as in the European Convention of Human Rights, which is binding the member states and in the future the European Union. And that the citizens, of course, also expect that, because they feel that it would not be legitimate for the European Union to rule something which is undermining the provisions of especially member states' constitutional principles and fundamental rights provisions. And in some member states, we know that courts already have said clearly that this is a no-go for the European Union. And therefore, we have to have a very high sensitivity on fundamental rights issues and on constitutional principles when we talk about fundamental rights rules on the European level, especially when we talk about a regulation which replaces fundamental rights provisions in the member states. So data protection provisions will be replaced, data protection law in the member states will be replaced in that scope which the European data protection regulation will have. Second, if you want my data, ask me for consent. I think that is what most, or if not all, of the citizens and consumers in Europe think if they think about their personal data. I don't want people to process my personal data which I don't know and I don't have any relationship to. I think that people really trust in the policymakers to follow the line that their consent is the leading principle of data protection, because that has to do with their foreseeability of what they agree to and what they can control in their personal life. And if they wouldn't be able to at least know that they have at any time that they have done something related to their personal data, that they put it somewhere, that they inserted somewhere, that they bought a product and perhaps there were personal data involved, so that they were aware of it, that there is no legal ground for data processing if that is not the case. That doesn't mean that there are also other grounds for data processing than consent. There are, in the provisions which the Commission proposed, those provisions, and there will be in our changes also those provisions. This is, of course, if you are having a contract and you are agreeing on things which therefore involve data processing with your foreseeability, that is an expression also of your consent, then there is a legal ground for processing. If there is a legal provision which allows, for example, an authority or also a private company, or even which forces someone to process personal data, then of course this is also a legal ground for processing. If there is a vital interest, so a threat for life or really adequate vital interest to that, then of course there is a legal ground for processing. And last but not least, but only then if that is not, all that is not possible as a legal ground for processing, and that is clarified by my report, only then there is something called the legitimate interest of the processor or the controller to process personal data. And different to the Commission proposal, we didn't want to leave that up to interpretation by the European Commission or somebody, but we wanted to draw clearly or to line clearly out legal certain provisions which says how this balancing of interest which is taking place in the last resort can be done, and when it applies, and when the individual rights of the data subjects overrule these interests. Therefore, we foresee clear rules. We try to give legal certainty to all of us, to consumers and citizens on the one side, but also to enterprises, to authorities, to data protection authorities also, to data protection officers. And we try to have less exceptions generally to the basic principles and rules we have, to the principles of data protection. Those should be leading and clear for everybody. And we try to guide through all our changes one principle, which is more transparency. More transparency about what are the individual rights, what are the data processing, what are the data processing mechanism, also like profiling, which are taking place. We give transparency and legal certainty to consumers and citizens on the one side, but also transparency about the question, what are the duties of the data controller, the data processor, and what has to be done to reach accountability. And that is important also on the side of those who want to assure that they can do their data processing activities without being hindered by other people who think that they are not accountable. So they should show and be able to show that they are respecting these legislative provisions, and that should be as transparent and clear as possible. Third, the rules have to be set by the legislator. Legal certainty is something which, especially in a regulation of the European Union, is the most important what we as legislator can provide for. And therefore, we have to set the rules as precise as possible. When it comes to definitions, for example, to the definition of personal data and data subject, when it comes to definitions on profiling, for example, that needs to be set. But also when it comes to rules, for example, the duties to the controller, what he has to do to comply with the law, then it has to be precise as possible, what we are asking for. And of course, it has to be as precise as possible for the data protection authorities at the end to enforce these provisions and for the courts to interpret these provisions in the line of the treaties and the other provisions around that. And therefore, we very much reduced the amount of empowerment to adopt delegated and implementing acts to the European Commission, which was foreseen in the European Commission's proposal. This empowerment, it has to be said again and again, is of course something which is not only given to the European Commission, but which always lies in the hands of the European Parliament and the Council afterwards also. But it's an easy way to change the legislative provisions, and therefore should be, and to accompany it also with different technical rules, and therefore it should be absolutely reduced to those things which are not the core of the content, but only technical provisions. And therefore we reduced those empowerments to technical provisions, like to standard forms when it comes to implementing acts, and to the guidelines on, for example, an icon approach, which gives me the opportunity to understand better privacy conditions, or, for example, the auditing mechanism, which is hopefully leading also to somehow a unified privacy seal mechanism. Those provisions are foreseen empowerments to adopt delegated acts. Those are technical ones, and those then will be, that's the nature of a delegated act, still decided by European Parliament and Council, and therefore still in our hands. 4, wherever personal data of EU citizens is processed, the EU data protection regulation should apply. The territorial scope of the regulation, which was proposed by the Commission, is strengthened by us in our changes. So whenever somebody offers products or services on the European market, and that's also our approach when it comes to market regulation and to competition law, then European law has to be respected. So the European data protection regulation has to be applied. Whenever data subjects in the European Union are processed, are part of processing, then of course, or monitored at least, then of course they should be certain that European data protection law is applying. 5, economic growth and data protection are no contradiction. With our proposals and with the European Commission proposal, we try to create better competition. That, of course, is, for example, done with the data portability provision also. But first of all, it's done by the one-stop shop and the level playing field which we create, so that everybody has to respect the same rules and not different rules in Europe. We create, therefore, a single market, and we create trust and innovation, for example, and for especially privacy technologies, where we think that the European economy can play a leading role in the global market by the principles of privacy by design we introduce, and the new possibilities to create also techniques to anonymize and pseudonymize products. I think, and we think, that the European market can play an important role, especially in privacy-enhancing technologies. But generally, the growth perspectives are ensured by a high level of data protection, because it creates trust in a global market and in a digital environment where cloud computing is more or less the rule. 6, we want a single contact for companies and citizens. As I said, the one-stop shop will be remained. We will make sure that this is for both sides, for on the one side, the data controllers and processors who have one single contact which they have to deal with. which then is competent also for measures towards this data controller. But on the other side, of course, every data subject and every individual also has the possibility to contact his or her data protection authority in his constituency and in his language and so on, and that then at the end the data protection authorities find common measures and common interpretation. 7, maximum data protection with minimum red tape. We make sure with our proposals that documentation, for example, as the main burden for the controllers is only necessary in this scope how it's necessary to ensure the individual rights of the data subjects, especially when it comes to information rights. That's an important point, because we don't want to create additional burden which is not necessary to ensure the individual rights of the data subjects. 8, a company's data protection officer should get the responsibility to ensure accountability. We ensure that everybody or every company which appoints a data protection officer therefore also gets the possibility to assure accountability with this data protection officer. He is then responsible, or she is then responsible to carry out, for example, the prior consultation and the data protection impact assessment in the company, and then is liable towards the data protection authority. That's something we want to clarify in the direction of the data controller, but therefore also to ensure that data protection officers in an environment of cloud computing is also appointed when there are a huge amount of data subjects who are subject of the data controller in 1 year, and not without regard to the number of employees in this company. 9, the European Data Protection Board will ensure the coherent application of the law. It's clear that the European Data Protection Board, as I said, will carry the main burden now for finding common interpretation and common measures to enforce the data protection regulation, and therefore be also the last point where a decision will be taken over the Data Protection Board. That's the independence of the Data Protection Authority, which is assured by the EU Treaty. There's only the European Court of Justice who can decide differently. 10, sanctions should be strong but clearly guided by proportionality. We follow the approach of the Commission to have strong sanctions. We follow also mainly the approach how these sanctions are worded. But it's clear from our side that it's in the hand of the data protection authorities and the Data Protection Board. And of course, also it should be clarified in the regulation very clearly that proportionality has to be met in all cases. If there is a difference, if there is a global company acting on behalf of many data subjects, or if there is, for example, a local authority or local small and medium enterprise who is not compliant with the law, this has to be ensured, and that's my last point. Now I would like to give the opportunities for as many questions as possible directly to you. Thank you. Okay, please.
So from your active, you just mentioned quite briefly the right to be forgotten. A meaningful balance between freedom of expression and data protection must be struck. Could you talk a bit more about what that meaningful balance is in practice?
Thank you for that question. It's perhaps an important point which I really should have added. We strengthened the protection of the freedom of expression in both parts, in those parts where there is the clarification that the rules of freedom of expression are limiting the data protection regulation in how far those rules are defined by the member states. that this has to be respected in the view of the freedom of expression protected through the Charter of Fundamental Rights and the European Convention of Human Rights. And on the other side, also in the right to be forgotten, where we clarified that the right to be forgotten has to respect the freedom of expression clearly, and that it is focused on those on a right which is an annex to the right to deletion, so that I can trust if somebody is transferring or publishing my data without my explicit consent, without my knowledge, then I have the right that this data controller has the liability to then delete or to ensure the erasure, and therefore to ensure my right to be forgotten. Thank you very much.
Sorry, I'm not at all clear about what this means in practice on the right to be forgotten. Is it your belief that after the implementation of these data protection rules, existing data held by, for example, social network sites will be required to go back to individuals and ask them whether or not they need permission to continue storing data or not?
That is not an issue of the right to be forgotten. That's an issue of the consent of the data subjects, which is necessary, of course, for those services to be conducted also in the future.
How would you expect your provisions on data portability and getting data free of charge from companies to affect internet firms like Google, Facebook, Microsoft? Another question about data controllers. Data controllers outside the EU, they would be subject to your rules under your proposal. How do you expect that to work in practice?
First, the data portability provision has been clarified from my side in this way that the right to data portability is limited to those cases where I insert my personal data into a system or into a processing activity, and but it's also clarified that this information has to be given without hindrance and in a format which is commonly used. So it has to be provided that I have the possibility to go with my personal data to a different provider. That's also somehow a strengthening of the competition in the digital market, and for data subjects to have different offers, offering also different terms of privacy rules. And the second question I didn't get really.
It was about data controllers outside the EU who, from my reading of your proposal, would be affected, would have to follow the rules of this proposal. How would that work? I mean, they wouldn't be based in the EU. It might be difficult to contact them. Just how do you see that working in practice?
Thank you. As I said, the territorial scope also implies data processors and controllers outside of the European Union if they fall into this scope. And normally there should be a representation in the European Union if you act in the European market. If that is not the case, then the competent data protection authority, the lead authority, will be appointed by the European Data Protection Board. And therefore, it's clear the scope is determining which companies will have to follow these rules, and the consistency mechanism clarifies the main establishment question of that. So I have the impression that we have to come to an end. Can we have one last question? No.
Because we have really, they called me from the services.
Okay.
Scheduled, but outside.
But I would like to say clearly that I have the opportunity to stay half an hour outside to answer more questions, so please don't hesitate to just contact me directly outside. I'm sorry for the limited time. Half an hour is not very much for such a dossier. Thank you very much.